Hi everybody, a very warm welcome to Thorough Newspaper. This video is for the 16th of April 2024. So now let's quickly proceed and have a look at the pointers of discussion for today. So you know that the first segment that we discuss is the editorial segment, and here we again have Indian Express article, and this article is indeed interesting. See, I'm sure a lot of you who are let's say judicial aspirants for quite some time, and you've attempted a couple of past years, you must have come across a question asking that, which is the case law in which the concept of curative writ petition, it was devised by the Supreme Court. Right? So I'm sure you must have seen this question. So in today's article, the title of that, I would like to read that out. It is, why Supreme Court's curative petition relief for Delhi Metro case, it is significant. Now, if I were to ask you to point out certain terms which you can see are, prominent in this article or this heading of this article, what would be those terms? Wouldn't it be curative petition? Wouldn't it be Delhi Metro case? So that, student, essentially is going to be the core of discussion for this article. We are going to understand the concept of curative writ petition by using this case of Delhi Metro. This is going to be very interesting for us to understand. And secondly, we talk about the news updates. And this is going to be followed by the last segment of legal news. So now, without further ado, let's start with the article discussion, and let's first see the title of this article. Why Supreme Court's curative petition relief for Delhi Metro, it is significant. Now, before we get into the context of this and, start with outrightly with what the Supreme Court said and why the Supreme Court said what it said and what is curative writ petition, I would like to give you a brief structure to this case, so that, you are in a position to follow whatever it is that I'm saying, or what are the entities involved here, what is the arbitral award, and all of these things. So please pay attention. See, in this particular case, there are two entities. Okay. The first one is the Delhi Metro Rail Corporation, and the another entity is the Delhi Airport Metro Express Private Limited. Now, this, which is the Delhi Airport Metro Private Limited, it is an Anil Ambani-owned Reliance infrastructure company. Now, these two entities, they had a work arrangement. They entered into an agreement for the same. And while the work was carried out, there was a dispute. Now, we know that whenever there is a dispute which arises in, let's say, any commercial transaction, or where there is any commercial nature of dispute, often the parties, they have an arbitration clause in their agreement itself. And invoking that arbitration clause, what they do is they approach and, before an arbitral tribunal, constitute the tribunal. And then what do? They, try to resolve their dispute using this alternative dispute mechanism. And as a result, the tribunal, the arbitrators, the panel, it then gives a certain award, asking, one of the parties to pay a certain amount to the other party. So similarly, this is what has happened here. Both of these entities, they had a work arrangement. It did not work well, and they had a dispute. It was resolved with the help of alternative dispute resolution. And as a result, the arbitration tribunal, it gave a certain award. The arbitration tribunal did not rule in favor of the DRMC. So then what must have been the award of the tribunal? Certainly, the tribunal, it asked the DMRC to pay an amount of rupees 8,000 crore to this infrastructure company. Now, as a result, aggrieved, the DMRC, or to say the government, it then, approached the Delhi High Court, single judge bench. Then the Delhi High Court single judge bench said certain things. Then the matter reached the Delhi High Court division bench. And eventually, the matter was before the Supreme Court. Now, what transpired before the High Court? That we'll understand later. But for now, to understand the context, let's see what happened before the Supreme Court. See, Supreme Court was approached. Supreme Court then upheld the arbitral award. This happened in September of 2021. So in September 2021, the Supreme Court said that we are at the position where which, the matter initiated. That is to say, the Supreme Court said that the arbitral award, it is absolutely fine. And DMRC, it has to pay an award, an amount of rupees 8,000 crore to this infrastructure company. So this happened before the Supreme Court, and this verdict was delivered by two judges of the Supreme Court. Who are those judges? We'll see later. Then the Supreme Court was again approached by something called a review petition. Please understand, review, it is the final step in appeal process, after which a ruling which is given by the highest court, here the highest court for land of our country is what? It is Supreme Court. So when the highest court, it attains finality, the judgment or ruling of the highest court, it becomes the law, it attains finality. So then a question might arise, what was the Supreme Court's decision in review? So just like the Supreme Court, in September 2021, upheld the arbitral award, the review petition was also dismissed by the Supreme Court. And as a result, the arbitral award was upheld. So this means that technically speaking, if we see this particular, legal reasoning and position, what does it say? It say that, DMRC, it was left with no other option. DMRC had to pay the amount and the award was upheld, correct? But very interestingly, 2 years later, which is on Wednesday this year, the Supreme Court ruled that Delhi Metro Rail Corporation, it will have to pay nearly 8,000 crore. It will not have to pay this amount to the infrastructure company. So essentially, the Supreme Court has now overturned that arbitral award. So then what is this mechanism using which this verdict of the Supreme Court has come? This is a legit question. So please note, student, this is something called a curative writ petition. The Supreme Court has now exercised its extraordinary jurisdiction in a curative writ petition to correct a fundamental error in its judgment of 2021 and then further its review dismissal. So now let's understand the history of this case, and for that we'll not get into a lot of technicalities of the facts, as in the terms and conditions of the agreement, which entity was to carry out what, which entity was at fault. We'll just understand what was the agreement about, then we'll see what was the arbitral award, then we'll see what happened before the High Court and before the Supreme Court, and then eventually we'll discuss the concept of curative writ petition. So see, if we have a look at the responsibilities that were vested upon both of the parties, so DMRC, it acquired the land and it bore the construction costs, while the consortium, it was required to, let's say, design, install and commission the railway line in a period of 2 years. Now, eventually the work was, it started, and in the midway, there was a dispute which arose between both of these entities. And as a result, the consortium, it triggered a termination of its agreement, and the consortium alleged that, there were some technical lapses and problems which led us to not carry out our work properly. And as a result, we suffered losses, and the responsible entity for that would be DMRC. This was the allegation of the consortium. So eventually, certain, arrangement was worked out, and the government and Reliance, they began a battle before the arbitration tribunal for the losses due to cancellation of the agreement. So then in 2017, a panel of 3 arbitrators decided in favor of Reliance and ordered DMRC to pay nearly 8,000 crore as arbitral award. Now, this included termination payment of nearly 2,782.33 crore, including interest to the tune of 11%, bank guarantees and expenses incurred in operating the metro line within the few months between the decision when the termination of the agreement was made and the date on which Reliance handed over the entire operations to DMRC. Now, as a result, as was expected, DMRC, it felt aggrieved. So then what was the mechanism for us to seek a redressal of that? It approached the Delhi High Court. Now, a single judge bench of the Delhi High Court said that I'm not going to refuse into the award which was given by the tribunal. And as a result, DMRC again felt aggrieved. So we know that, there is a mechanism of intra-appeal. So what happens in an intra-appeal is that, let's say, when a single judge bench of the High Court has, refused to grant you relief, then what you do? You approach the division bench of the High Court. So this is an LPA, also called, the term that often you see is an LPA. So this is an intra-court appeal. So here then, the matter was before a division bench of the High Court. Now the division bench then overruled this verdict. So there was some relief for DMRC because then, this division bench, it said that the tribunal had not considered some key elements and facts of this case, and it had some ambiguity in interpreting the entire fact and matter before it. So therefore, this decision was not correct, and it sort of overturned the arbitral award. Now then, this time around, Reliance was aggrieved. So from High Court, where do we go? To the Supreme Court, correct? So then the matter reached the Supreme Court. Supreme Court then heard the matter, and in September of 2021, reversed the Delhi High Court verdict. So that means, this is what we saw in the context para, that the Supreme Court upheld the arbitral award. And while doing so, the court made certain observations on, how the judiciary should not interfere to a great extent and should have a restrictive approach when it comes to, let's say, dealing with arbitral award challenges. So a division bench of the Supreme Court comprising Justices L. Nageshwar Rao and S. Ravindra Bhatt, they underlined, or to say they highlighted, that courts must exercise restraint when interfering with arbitral awards. And why the court said that, there should be a limited sort of an interference? This is because arbitration, we know, this is a special statute. It is institutionalized, alternative form of dispute resolution, and we know there is a law, a full-fledged statute for that. And it is devised and it is regulated by the 1996 Arbitration and Conciliation Act to ensure speedy disposal of cases, especially commercial matters which suffer due to delay in judicial system. The legislation and a plethora of Supreme Court judgments underline this aspect of minimum judicial interference with arbitral awards. So then a revision petition was filed before the Supreme Court which sought, if I've been saying revision, then you just please correct, it is review. So then a review petition was filed before the Supreme Court seeking review of its earlier, September 2021 decision. So then the review was again dismissed by the Supreme Court, and almost 8 months later, DMRC, it filed the curative writ petition, which is the last resort to correct the judgment of the Supreme Court. So now let's see what is curative jurisdiction. Has it already always been in our law, or is it a judge-made or judge-devised, sort of a mechanism? So let's see. Curative writ petition as a layer of appeal against a Supreme Court decision, it is not prescribed in the Constitution. It is rather a judicial innovation which is designed for correcting grave injustice in a ruling of the top court. The Supreme Court first articulated this concept in the landmark judgment of Rupa Ashok Pura versus Ashok Pura. This is a 2002 verdict. Please make a note of this case law. This is often asked in your prelims examination as well. If there was a significant miscarriage of justice due to a final decision of the Supreme Court, could the court still correct it? This is the question. So on the one hand, the issue of finality and closure of the case is there. But on the other hand, there was a substantive question of rendering justice in its truest sense. Now, this makes sense also because you know how litigations in our country, they last for years and even centuries in civil disputes particularly. So given that, we had to balance two considerations, right? One is the cause of, putting a closure to a case, stabilizing the rights of the parties and giving, at large a stability to the society. The legal rights are concreted. There is a finality of the verdict. And we know that, the state interest, it also lies on finalities of the decisions, correct? But on the other hand, there is a substantive question of rendering justice. So therefore, in answering this question, the Supreme Court said that its concern for rendering justice in a cause, it is not less important than the principle of finality of its judgment. However, the court also treaded very cautiously, and it said that curative writ petitions, they should be used very sparingly. Sparingly, which means that only, let's say very exponential, say very, case laws which have certain exigencies, certain circumstances would justify the exercise of this extraordinary judicial power. So there are narrow, the cure of curative writ petition, it is narrow, mostly procedural grounds that permit the filing of a curative writ petition. A claim must be made that principles of natural justice were not followed. What does this concept of natural justice encompass? that, let's say, the party was condemned without being heard. Then secondly, the judge was biased or had any conflict of interest with the parties concerned. So these petitions need to be approved by senior advocates who are designated by the Supreme Court itself. Curative writs, they are filed mostly in death penalty cases, and we saw such curative petitions filed, let's say, in the case of Yaqub Menon in the case of 2015. Then we saw similar things happening by the convicts of the Delhi gang rape case in 2020. So both of these petitions were dismissed, and eventually, the death sentences were executed. In 2023, also, we saw something called the curative writ petition in the case of Bhopal gas tragedy. We also discussed this in our TNA. So in the case of Bhopal gas tragedy, certain compensation was granted for the victims, correct? But now the Supreme Court was again approached saying that this compensation, it should be enhanced. So the Supreme Court, however, refused to exercise its curative powers to enhance the compensation which was provided to such victims. So now let's understand what now after this judgment for this case. So the restoration of 2019 position, it means that DMRC, it does not have to pay the arbitral award. About rupees 2,600 crore that DMRC, it had deposited with the Delhi High Court in an escrow account that will be resorted and restored. So allowing a curative writ petition at the government's instance, almost 2.5 years after its final verdict, it marks a significant moment in the way the court has exercised its wide powers. Lawmakers, they often argue for judicial restraint, especially with regard to exercise of powers that the court has given itself, that may not be, let's say, expressly devised in the constitution, but it is judicial innovation. So in those powers exercise, especially, lawmakers have often been arguing that, the judiciary should ascribe or, abstain and should exercise a certain sort of restraint. So while the government had high stakes in this case, each exercise of the curative jurisdiction, it could have a bearing on investor confidence. So that also needs to be looked into. And with this, we proceed to the next segment for today, which is of the national news. See, UPI rule change. Money in PPI wallets can be spent using any UPI. PPI customers, PPI stands for prepaid payment instrument. So PPI customers, they can use any of their UPI apps to access any of their wallets, even if the wallet and the UPI app belong to different companies. Next up is an update in the segment of defense for today. India-Uzbekistan joint military exercise Dustlik. The 5th edition of this joint military exercise called Dustlik, this is between India and Uzbekistan. It commenced on 15th of April. And the venue of this exercise, it is a district which is called Termez. It is in Uzbekistan itself. This is a 15-day exercise from this is going to be lasting from, this is a 14-day exercise from 15th of April to 24th of April. So what we need to remember for our exams is the name of this exercise and the parties, which is India and Uzbekistan, and maybe the 5th edition of it. Mary Kom, she stepped down as India's chef de mission for Paris Olympics. If you remember, a couple of days ago, we did a story on how, torch bearers and chef de mission, they were appointed for the Paris Olympic of 2024. So now this is a subsequent update therein. Boxing legend Mary Kom, she's resigned from his position as the chef de mission of India's Paris 2024 Olympics. She had been appointed to this position on 21st of March. So now let's understand what is the role of somebody who's, holding this position. Chef de missions, they are tasked with looking after the athletes and their well-being. They are also the point of contact with the various organizing committees and the sporting members of the contingent. This is a factual trivia for the Paris Olympics. Let's say the schedule of it. So it is going to commence from 26th of July to 11th of August 2024. Then this is in 19 days of competition. There are about 329 events. Then there are about 32 sporting categories with the addition of 4 additional sports this time. And we are going to witness about 10,500 athletes compete and show their best performances at this mega sporting event. Kannada poet Mamta G. Sagar wins International Literature Prize. Kannada poet, playwright, and academic Mamta G. Sagar, she was awarded the World Literary Prize for her contribution to literature by the World Organization of Writers, and this happened in Nigeria. Next up is another update in the segment of appointments. Jagjit Pavadia re-elected to International Narcotics Control Board. Jagjit Pavadia of India was re-elected to the International Narcotics Control Board, getting the highest number of votes in a highly competitive election, which is conducted by ECOSOC. What is that? It is the United Nations Economic and Social Council. Now we proceed to the international segment for today with the first update coming from UK. So interestingly, UK has added Pakistan to the list of countries which is too dangerous for its citizens to travel. The Foreign, Commonwealth and Development Office of United Kingdom, it has recently added Pakistan to its list of countries that it states are too dangerous for UK citizens to travel. Now, what are the parameters as to, what are the reasons why this dangerous category can be invoked? It may be either whenever, there's threat to the visitor's safety due to crimes, due to wars, due to terrorism activities, due to any sort of disease, any harsh weather conditions, or natural disasters. If I were to give you a list of other countries which are blacklisted, this is right here on your screens. So it includes Afghanistan, Burkina Faso, there's Central American Republic, African Republic, then there's Chad, Haiti, Iraq, Israel, Lebanon, Libya, Mali, Niger, then there's North Korea, Somalia, Somaliland, then there's South Sudan, Syria, Venezuela, and Yemen. Former NFL star O.J. Simpson dies. O.J. Simpson, the American football star, he dies and passes away at the age of 76. He was also acquitted in 1995 in the case which is also called, the trial of the country for the murder of his ex-wife and a male friend. Now with this, we proceed to the legal news update segment for today with the first update coming from the Supreme Court. So the Supreme Court has observed that the claimant of an easementary right, by easementary right, what do we mean here? Let's say a right to waive from a certain property to access your property. So the Supreme Court has observed that the claimant of an easementary right wouldn't be entitled to claim easementary right by necessity for enjoying the dominant heritage. What is dominant heritage? It is essentially the property which is owned by the claimant. So let's say if a claimant is before a court and the claimant is saying that I have a property and in order for me to access the property, I have to have a way through another property. And I am claiming this easement, and that right of way is what? It is easementary right. And now the claimant is saying that I'm claiming this easementary right through the other property by necessity. That is to say, I don't have any other, way of approaching my property. So I have to take that way. So this is easementary right by necessity. So the Supreme Court has said that such claimant who is claiming such right wouldn't be entitled to claim easementary right by necessity for enjoying access to his own property where there exists an alternative way to access the dominant heritage apart from the way over which the easementary right they were claimed to access the dominant heritage. So if there's alternative way available, then by necessity easementary right you cannot invoke. The easementary right by necessity could be acquired only in accordance with Section 13 of the Indian Easement Act, which provides that such easementary right would arise if it is necessary for enjoying the dominant heritage. The court further said and explained two terms which are important. One is dominant heritage and another one is the servient heritage. So dominant heritage, as we already saw, is the property right concerned of the claimant. So dominant heritage is the land that is to be enjoyed by the beneficiary, whereas the land on which the easement is claimed, that is the servient heritage. The name of this case is Manish Mahendra Gala versus Shalini Bhagwan Avatar Ramani. Now let's proceed. Another update from the Supreme Court, another important update on constitutional law and its interface with the NDPS Act. So the Supreme Court has recently observed that Article 20, Clause 3 of the Indian Constitution, it is going to remain unaffected by the provisions regarding search, regarding seizure of the material under the Narcotics, and Drugs and Psychotropic Substances Act, which is the NDPS Act. What is Article 20, Clause 3? That's important for us to understand. See, this article provides a protection against self-incrimination. It means that no person who is accused of an offense should be compelled to be a witness against his own self. So the court essentially has said that this protection, which is given under 20 Clause 3 of Constitution, it remains unaffected by the provisions of search and seizure, which are made available under the NDPS Act. The name of this case is Najmunisha Abdul Hamid Chandmiya alias Laddu Bapu versus the state of Gujarat Narcotics Control Bureau. So with this, we come to an end of our TNA. Thank you so much for being with us and have a wonderful day ahead.